Alameda Research CEO Caroline Ellison has her court transcript from the Southern District of New York unsealed. She is seen as saying, "I am truly sorry for what I did. I knew that it was wrong," pleading guilty to federal fraud and conspiracy charges, carrying over 100 years in prison. What does it all mean for the ongoing FTX saga? Joining us now to discuss is Ian McGinley, white-collar defense and government investigations partner at law firm Akin, Gump. Hello, Ian. Thank you for joining us this morning. Good to see you. So former FTX CEO Sam Bankman-Fried has his next hearing scheduled in Manhattan in federal court on January 3rd. He'll be arraigned and asked to enter a plea to 8 criminal charges. And we see that Alameda Research CEO Caroline Ellison and FTX co-founder Gary Wang, his inner circle of friends and colleagues, have turned on him, and prosecutors are encouraging others to come forward. So it's pretty damning. He's maintained his innocence this entire time. But with this testimony, what would your advice be to him? Should he plead guilty?
Well, look, there are still just allegations against Sam Bankman-Fried. That said, these developments recently about Caroline Ellison and Gary Wang pleading guilty are game changers for the case against Sam Bankman-Fried. We saw after all of this news on FTX and potential fraud, he came out, he made public statements, and essentially what he said was there might have been mistakes and mismanagement, but I didn't intentionally commit a fraud. That's what you need to do to be guilty of a crime. Now you have 2 people, 2 insiders who were with him presumably during all of the pivotal moments at stake in the case, saying, we conspired with others, presumably Sam Bankman-Fried, and we intentionally did something wrong. So that is very difficult if you are defending Sam Bankman-Fried to overcome, because you could say maybe one of the cooperating witnesses is lying, but when you get to two cooperating witnesses, it's much harder to make that case before a jury. So I think it remains to be seen. These cases take a little while to play out, but it is very much a game changer that you now have 2 witnesses cooperating in the case.
Right. So in this case, would it be better to go for a plea bargain rather than going through a full jury trial that may not look kindly on it?
It's an interesting question, because the way SDNY does it is there's no kind of raw bargaining like this is a market kind of matter. You get a good plea deal, so to speak, and you get leniency with SDNY if you cooperate. And cooperate means essentially, in very blunt terms, you're pointing the finger at someone else and saying, I can give you, prosecutors, evidence against someone else, and for that reason, I should get leniency at sentencing. The issue here that he faces is he is the head of FTX, right? He is the buck presumably stopped with him. So it's it's hard to see how he could cooperate at all. So then you're in the scenario of you just plead guilty. And there have been comparisons made to the Bernie Madoff case. That was a quick guilty plea, and Bernie Madoff still got a very substantial sentence. So the options here are very limited.
So Ian, on that note, though, can he ever get the Elizabeth Holmes deal, if you will? 11 years in prison, and if he doesn't have a baby, maybe a little bit longer. But that said, does he have any hope in that? If he were, let's say, to show, I don't know, U.S. Bank was involved in somehow in what was going on, that a U.S. bank either knew about it or turned a blind eye? Is there a way for him to pass the buck onto a major institution, major financial institution, as a way to sort of get some leniency here? And number 2, did his media tour, any of that, as you mentioned, him saying, well, it wasn't intentional. I don't know. There was Alameda. Alameda was sitting next to me. She was there. But I thought she was in another state, another room, another island in the Bahamas. I don't know how this happened. Did that whole thing blow up in his face and make things worse for him?
Yeah. So on your first question, it goes back to what I said earlier. I mean, it remains to be seen. I don't know. No one really knows what kind of information he could have that could be of value to prosecutors. I'll say, as we all know, cases, particularly in this space, there are a lot of surprises. Things change quickly. So who knows? You never say never. At sentencing, by the way, it's a very individualized process, just to give it to you in short. There's a judge. Sam Bankman-Fried lawyers will get a chance to make a case if he does plead guilty as to why he should deserve some leniency. And the government makes a case as to why he should get a particular sentence, depending on the nature of the crime. So we'll see on that. On your second point, I think most defense lawyers counsel against giving public statements like that. And I think in his interview with the New York Times, Sam Bankman-Fried said his lawyers were essentially not on board with him giving those statements. And the reason is because each of those statements is really a gift to prosecutors or regulators watching, because they can compare those against every other piece of evidence they have in the case. And then they can see if there's any discrepancies. And they can do that in this case with so many statements, including on social media, right? Sam Bankman-Fried was tweeting in real time about what was happening. Those statements, some of which are in the indictment, right? So that's a sign that prosecutors paid attention and are actually using some of these statements against him. And all they need to show, and I've talked about this a lot, in crypto, the most powerful statute is wire fraud, which doesn't depend on whether, think about all the complex debates we have in crypto. Think about all the complex concepts, even in the legal space, whether a token is a security, whether it's a commodity, whether it's something else. Doesn't matter here. Really doesn't matter. There are some parts, and we could talk about it in the SEC's recent charging instrument, where they do allege that the FTT utility token is a security, and that's interesting. But by and large, the big charges in this case are lying in order to take people's money. It is a very simple crime that arguably has very little to do with crypto. And so for that reason, the more public statements you have, the more that prosecutors and regulators can dig into them and find inconsistencies and perhaps lies.
I smile because years ago I was involved in a case where I provided evidence for a mail fraud. And what a lot of people, I guess, especially in crypto, don't realize that the Postal Service has an incredible team of people, investigators and things like that. And that's their job, is actually to bust all these major criminals on mail fraud. But getting back to some of this issue, we see this a lot in crypto, that a lot of CEOs think that they don't need counsel, they don't need lawyers, they don't need communications people, and that they can go on Twitter to handle their public relations, that they can control it. A lot of these guys are, they're kids, basically, arrogant, horribly arrogant. Let's just face it. Let's be honest here. Do you think that changes? I mean, is this going to be a boon, do you think, for attorneys now who are covering the crypto space, that they'll now have a lot more humble customers in CEOs? Or do you think that, just looking at this, these guys haven't learned a damn thing? I'm betting on the latter, by the way.
It's busy on this end. I think every lawyer involved in the space will tell you the same. I think what you said is very interesting, right? If you look at public companies, there are disclosure committees. There's a whole process for public companies to make public disclosures. And that's for good reason, because the market relies on public statements. Investors rely on public statements. It's very important. And there's a lot of people involved, not just lawyers, although there's certainly a lot of lawyers involved in that process. But it's a very careful, deliberative process. Think about all the SEC filings, the 10Ks, 8Ks, right? Now you have crypto, a huge industry. And to your point, a lot of the disclosures are someone on Twitter making a very fast pronouncement, usually in response to a breaking news story. And I do think that will change. I think the big players in the industry, to the extent they aren't doing it already, are going to need to develop a lot of the protocols that you see at big banks, that you see at big companies, because the public relies on these statements, even on Twitter, even on TikTok, on any kind of social media. And not only does the public rely on them, but you have the prosecutors and the regulators at the SEC and the CFTC going through those statements with a fine-tooth comb.
Pay attention, Elon Musk.
We have to wrap up in a minute or two, but before we do, just want to ask you, the next hearing for Sam Bankman-Fried in federal court in Manhattan, January 3rd, what do you expect to see there? And, what does this mean for enforcement for other crypto firms out there going forward in the future into the new year?
Yeah, I think January 3rd is his next appearance. I think that's largely going to be a kind of ministerial, procedural appearance. It's very rare that a case is wrapped up, particularly one this big, that quickly. So I think that will really just be a showing up in court and scheduling motions, perhaps a trial date. I think in the new year, you can expect a lot of enforcement in this area. Last time I was with you all, it was July, and we were talking about the Wahi case, insider trading on Coinbase. There's so much fraud in this space, and regulators are really focused on it. And if you just look, DOJ has a prosecutor in every single office across the country focused just on crypto. The SEC has added their staff focused on crypto by 50%. Those folks are working hard. And I think we're going to see a lot in this space, and we're going to see all kinds of cases. We're going to see insider trading. We'll see more corporate disclosures, and we'll see market manipulation cases, the kinds of cases we see in traditional white-collar crime.